Hi, welcome, and hope you're all well and got your favourite drink, beverage ready for what I'm about to read out. It's Jeffrey Epstein's report from Palm Beach County. It's the first of its kind after the mother of a 14-year-old girl went to the police station because her daughter had £300 in her possession, and that's what basically started off the look into Epstein again. He'd already been looked into in 2006 over allegations, and this one was a lot more. He had to go to jail. Remember, he got that sweetheart deal where he went to court. So what happened, basically, he got that sweetheart deal. I think that was 2016, and then he got raided in 2019. I'm not sure how accurate this information I'm giving you is, but the report is the main report that will give us everything up to the point he went to New York. Just forgive me a minute, I just got to do my daughter's pasta. I'll be 2 seconds. So yeah, I think the report says on the top there, Jeffrey, and I think it was due to Jeffrey. I've got this document, by the way, from the Diddy Diaries podcast, and I just want to mention that because I've got a lot of my information from there, and he's a real honest, decent podcaster. Most of these podcasters are excellent. I've never heard any details from podcasters that I think accurate, where with YouTube you get a lot of inaccurate information about Epstein, the information getting out slower. So yeah, just think about what you're looking at and broaden your horizons with also audio. But if you don't like that, I could do it for you. I transcribe because I don't want people not seeing the documents. Also, the Diddy Diaries podcast puts the documents up with his stuff and reads it out, so I can't beat that really. He's really excellent. So I really wanted to read this one out myself because I may look into certain things, certain names that might come up, and put it with this one. I've learned how to cut and paste. I've learned how to edit a lot better, so I can do it. Because that's half the problem with my information. Has been really editing, and people have no patience for people who don't know how to edit and take forever doing their work. Here you go, darling. Your sister fell asleep. So yeah, I wanted to. I'm going to go upstairs in my house now. I've made her dinner. My daughter's fell asleep last night. Yeah, I hope you're having a lovely day. It's a lovely Monday afternoon in England. It's 4:30. The sun has come back out now. It's the first time as well I've ever turned brown instead of bright red in the summer. And I am so happy this summer. It's unreal. And it was because I bought this thing for me legs off TikTok. I never go brown. And it worked. I couldn't believe it. It worked. So if you want any tips like this or anything like that, because I'm an old lady, I'm 45, I know every tip in the book. So far. I don't like to wear makeup very much because I smudge a lot with my eyes and everything. But I love putting makeup on, I love makeup, I love what it does, it enhances everything. So I apologise sometimes, I don't make more of an effort, and I suppose that does look unprofessional. I'm going to try and improve these things about myself, excuse me. It's just that I've had depression for about 2 years now, and I don't know what it is. All my physical appearance has changed. I used to be very into myself, I think the word would be, like always dolly doll. But the last couple of years, I've not been like that. And I was having these dizzy spells where I pass out and that. Yeah, and it's panic attacks. So yeah, I'm getting more confidence is going with this as well, thanks to YouTube, because it's given me a lot of realisation that I am more than a blonde, blue-eyed bimbo. There's more to me than that. It's given me courage to do things like this, and I recommend if you start a channel that you don't pay attention to negativity whatsoever, ever when you're doing it, because some people, I'll be honest, I've been guilty of it. I've made assumptions about people and I've been absolutely wrong. And I hate being wrong, man. I hate being wrong. But you've got to admit when you're wrong. You know what I mean? It's part of being a woman, you know, if you can't admit it. So please forgive me if I have made assumptions. But I always, if I'm subscribed to you, it means I think the world of what your content is, I'm going to be honest. I had a case of like when I had the channel, I don't know what happened, but I subscribed to the ones I always watch and they went off me thing and I was gutted because I had to resubscribe. But people who I possibly was with for ages thought, wow, were you resubscribing for? I thought you were already subscribed, you know, and I felt really bad because it looks so bad. But I honestly can't say what happened. Maybe I did it, you know, and I just didn't know which I was on, either Facebook or TikTok, you know, because sometimes I think I'm on TikTok and I'm on YouTube. I still think that. I know it's daft, but I'm trying to get a glance at my neighbour's baby. Yeah, I know you have one, but it's like, never see her. Well, I'm so nosy. Anyway, this document, yeah, Miami Herald brought it to light to the police by signs of this report as well, because it has their name here, interveners, applicants, you know, applicants, and then Ghislaine, and then the plaintiff at the bottom. I've never seen that done, but listen, I'll be honest, I have no idea about these people. I don't assume that because I have been a secretary in law that I know it all, because I don't. I use dictation. I didn't even write shorthand, but I know when a piece of paperwork is not enough. I read the Diddy indictment, remember, and I went to study because I expected a lot more victims on that indictment. Yeah. And I do think this is all a convenient humiliation thing, ritual for Diddy. I have no idea. So it has the dates here of each order filed, the document description, the docket text, unsealed summaries, the judgment record, the mandate, unsealed summary, judgment record. Yeah, all on the same day. United States Court of Appeal for the Second Circuit. The stated term of the United States of Appeals for the Second Circuit held at the For Good Marshall United States Courthouse, 40 Foley Square in New York, on the 9th of August 2019. Jose Cabranes and Rosemary Bula and Christopher Droney, Julie Brown from Miami Herald, and then Ghislaine, and the plaintiff, and then on the other side, there's Dershowitz, Michael Kernovich, DBA Kernovich Media, interveners, applicants, and then Virginia Giuffre and Ghislaine as the plaintiff again. It is hereby ordered that the clerk is directed to issue the mandate forthwith for the court Catherine Hogan Wolf. It is 2,000 pages, no way. Mandate. Court of Appeal for the Second Circuit held For Good Marshall United States Courthouse, Foley Square in New York on the 3rd of July 2019. Jose A. Cabrinas, and I'm going to just go straight to the detail right next, because it's going to have this all the way through, because this is all printed out bits. Yeah, and it's going to keep going like that, right? It's going to go arguments, you know, who's arguing against who, the district court, so the conduct of requisite particularised review of ordering the sealing of materials at issue. At the same time, we recognise the potential damage to privacy and reputation that may accompany public disclosure of hard-fought, sensitive litigation. We therefore clarify the legal tools that district courts should use in safeguarding the integrity of their dockets. including we vacate the district court orders ending in November 2016, and May 2017 and August 2018, order the unsealing of summary judgment record as described further herein, and remand the cause to the district court for particularised review of the remaining sealed materials. Judge Pooler concurs on this opinion, except in so far as it orders immediate unsealing of the summary judgment record without a remand. And that was done by Christina Walsh. I think these names are important, don't get me wrong. But Dershowitz, to me, I found very strange with Virginia Giuffre that Dershowitz, you know, she did say that he was involved, and then she changed her mind and said, I got the wrong person, maybe he paid her off. And keeping that to it in her soul probably hurt her. Intervenants and clients Alan Dershowitz, Michael Kernovich, and the Miami Herald, company with reporter Julie Browner, jointly the Herald, appeal from certain orders of the United States District Court and Southern District of New York. Robert Sweet, denying their respective motions to unseal filings in a defamation suit, we conclude that the District Court failed to conduct the requisite particularised review when ordering the sealing of the materials at issue. At the same time, we recognise the potential damage to privacy and reputation, and may accompany public disclosure of hard-fought sensitive litigation. We therefore clarify the legal tools of the District Court should use a safeguarding and integrity of their dockets, accordingly, we vacate the District Court's orders entered on the November 2nd of 2016, May of 2017, and August of 2018 order unsealing of summary judgment record described further in, and remand the cause to the District Court for particularised review of remaining sealed documents. Now, it might sound like I'm saying the same thing over and again, but it's important for people to pick up exactly what I'm trying to say. You know, what I say speaks for itself, really. It's quite hard to follow, point things out to me, and I'll look back and I'll have a little brief 10 minutes before going into reading this on the next one and explain it. I don't mind. So please put anything you don't understand in there. Background A. Jeffrey Epstein's conviction and the CVRA suit. The origins of this case lie in the decade-old criminal proceedings against the financier of Jeffrey Epstein. On the 30th of 2008, Epstein pleaded guilty to the Florida state charges of soliciting and procuring a person under the age of 18 for prostitution. The charges stemmed from a sexual activity with privately hired masseuses, some of whom were under 18, Florida's age of consent. Pursuant to an agreement with the state and federal prosecutors, Epstein pleaded to the state charges. He received limited jail time, registered as a sex offender, and agreed to pay the compensation to his victims. In return, prosecutors declined to bring federal charges. Now, anybody who went to dinner with him after 2008, you want to really look into. Shortly after Epstein entered his plea, two of his victims, proceeding as Jane Doe 1 and Jane Doe 2, filed suit against the government in the Southern District of Florida under the Crime Victims Act. And the victims sought to nullify the plea agreement, alleging that the government failed to fulfill its legal obligations to inform and consult with them in the process leading up to Epstein's plea deal. Now, this is the thing with the federal court. They do a lot of weird shit, and the government do too. And you've got to watch. I never thought that things like this happen, but they do. They really do. On December 30th of 2014, two additional unnamed victims, one of whom has now self-identified as plaintiff Virginia Giuffre, petitioned to join the CVRA the victim's criminal, what was it called? The Crime Victims' Right Act. These petitioners include in their filings not only descriptions of abuse by Epstein, but also new allegations of abuse by several other prominent individuals, including numerous prominent American politicians, powerful business executive, foreign presidents, as well as known prime minister and other world leaders. Now, prime minister sounds like an English, yeah. And other world leaders, as well as Dershowitz, a long-time member of Harvard Law School faculty, who had worked on Epstein's legal defense, and defendant Ghislaine Maxwell. Now that is power. That is, Giuffre, she must have had something spirit in her to put that power, to never ever give up on it. She probably knew a lot of girls who ended their own life for it, you know. I'm grateful she spoke up. Dershowitz moved to intervene, seeking to strike the outrageous and impertinent allegations made against him, and to request to show court order to the attorneys that have made them, exercising its authority to strike from the pleading insufficient. And there was a footnote saying, on February 21st, 2019, Florida District ruled that federal prosecutors had violated the CVRA by failing to adequately notify the two plaintiffs of the plea deal. And that is like not as bad as like tampering with their questioning like they did in the Diddy case. I'm just speculating. The district court has not yet determined the appropriate remedy to Doe 1 versus United States. Insufficient defence or any redundant, immaterial, impertinent or scandalous matter on its own, brackets. The Florida District Court, Kenneth A. Marrara, Judge, Sponte, struck all allegations against additional parties from the pleading, including those against Dershowitz, and therefore denied Dershowitz's motion as moot. The stricken allegations, however, quickly found their way into the press, and several media outlets published articles repeating Giuffre's accusations. In response to the allegations on January 3rd of 2015, Maxwell's publicist issued a press statement declaring that Giuffre's allegations, brackets against Maxwell, are untrue, and that her claims are obvious lies. B. Giuffre sues Maxwell. On September 2001 and 2015, September 21st, 2015, Giuffre filed an underlying action against Maxwell in the Southern District of New York. Giuffre alleged that Maxwell had defamed her through this and other public statements. Extensive and hard-fought discovery followed due to the volume of sealing requests filed during the discovery. On the 9th of August 2016, the District Court entered a sealing order that effectively ceded control of the sealing process to the parties themselves. The sealing order disposed of the requirements that the parties file individual letter briefs to request sealing, and prospective granted all of the parties. So every party has to sign for this sealing. So you'd have to pay the victims for that, really, wouldn't you? Future sealing requests in total is 167 documents. Nearly 1/5 of the docket were filed under seal. Jesus Christ. These sealed documents included motions to compel discovery, motions for sanctions and adverse inference, motions in limine, and similar material. It stinks in his kitchen. I don't know what that smell is. On January 6 of 2017, Maxwell filed a motion for summary judgment. The parties submitted their memoranda of law and supported exhibits contesting this motion under seal. On March 22nd, 2017, the District Court denied the motion in heavily redacted 76-page opinion. Once again, the entire summary judgment recorded included the unredacted version of the District Court opinion, denying summary judgments, remained under seal. So when motions have been made, after the civil complaints, perhaps, they've been sealed afterwards, or let's see. Once again, the entire summary judgments record, including the unredacted version of the District Court opinion denying summary judgments, remained under seal. On the 24th of 2017, Maxwell and Giuffre executed a settlement agreement, and the case was closed the next day. C. Motions to intervene and unseal. Over the course of the litigation before the Judge Suite, 3 outside parties attempted to unseal some of all of the sealed material. On August 11th of 2016, Dershowitz moved to intervene, seeking to unseal 3 documents that, he argues, demonstrate that Giuffre invented the accusations against him. On January 19th, 2017, Kernovich, an independent blogger and self-described popular political journalist, moved to intervene, seeking to unseal the summary judgment record, and Dershowitz joined this motion. On April 6th of 2018, after the case had settled, the Herald moved to intervene and unseal the entire docket. The District Court granted each of these motions to intervene, but denied the related requests to unseal in orders entered November 2nd, 2016, May 3rd, 2017, and August 2018, respectively. Now, these could be other civil complaints of other very affluent people. We all know about the one with Trump, right, and Epstein. Now, I'm not saying that allegations can't all be true, but when you have things like records stuff, I'm not going to give people the opportunity to try and copy that, but you've got to track, you like it or not, if you get pregnant, there's going to be details at the doctor's, this and that, there's going to be noticed when you have a baby again, it's going to be noted because it's dangerous. Also, some of these girls had injuries that went to get help but didn't talk, The applicants timely appealed from each of their orders denying their respective motions to unseal, although each applicant seeks to release a different set of documents. So they wanted to unseal certain documents to make the public opinion change, but it's unseal them all. When you're doing this type of stuff, unseal them all. All argue that the District Court failed to analyse the documents individually or properly apply the presumption of public access to the court documents. We therefore ordered that the appeals be heard and held arguments on March 6, 2009, my birthday. On March 11, 2019, we issued an order to show the cause why we should not unseal the summary judgment motion, including any materials filed in connection with this motion and the District Court summary judgment decision. The parties timely filed their responses. 2. Discussion. There are 2 categories of sealed materials at issue in these appeals. 1. The summary judgment record, which includes the parties' summary judgments, briefs, their statements of undisputed facts, and incorporated exhibits, and 2, court filings made in the course of discovery process, and with respect to motion in line. I never know. I remember what that means. I should know because the Koberger case. In this opinion, we explained that our law requires the unsealing of the summary judgment materials and individualized review of remaining sealed materials. While the law of governing public access to these materials is largely settled, we have not yet adequately addressed the potential harms that often accompany such access. These harms are apparent. Over 40 years ago, the Supreme Court observed that without vigilance, court files might become a vehicle for improper purpose. our legal process is already susceptible to abuse. Unscrupulous litigants can weaponize the discovery process to humiliate and embarrass their adversaries, shielded by the litigation privilege, Yeah. So you can put a gag order on, so-called victims. And I say so-called victims, I mean people who weren't victimised in the sense touched. Make them be quiet, and then the obvious opinion changes over time, and it can change a case. It can, if you get that type of jury, Okay. Bad actors can defame opponents in court pleadings or depositions without fear of lawsuits and liability. Unfortunately, the presumption of public access to court documents has the potential to exacerbate these harms to privacy and reputation by ensuring that the damaging material irrevocably enters the public record. We therefore take the opportunity to describe the tools available to district courts in protecting the integrity of the judicial process, and emphasise the court's responsibility to exercise these powerful tools. We also caution the public to critically assess allegations contained in judicial pleadings. And that's right, we've got to look at things with caution, guys. We can't make assumptions because we don't like someone that they're going to be guilty. When the standard of review, the reviewing a district court's decision to seal a filing or to maintain such a seal, we examine the court's factual finding for clear error, its legal determination de novo, and its ultimate decision to seal or unseal for abuse of discretion. B. The summary judgment's materials. With respect to the first category of materials, it is well settled that the documents submitted to the court for its consideration in a summary judgment motion are as a matter of law judicial documents to which a strong presumption of access attaches under both the common law and the First Amendment. In light of this, the strong First Amendment presumption continued sealing of the document may be justified only with specific on-the-record findings that sealing is necessary to preserve higher values, and only if the sealing order is narrowly tailored to achieve that aim. These notes. Observe that the holding relies on general principles that parties may be assumed to have supported their papers with admissible evidence and non-frivolous arguments. That's what I mean. You've got to have evidence, because that's a frivolous argument to me. What's worse, typing a statement up when the witness could be lying and shows you no evidence? If there's no evidence to support it, you shouldn't write it. Tony Blackburn. Sorry, Tyro Blackburn. Insofar as the district court has, through striking a filing, specifically found that assumption I'm having a bad day. Implicable the the categorical rule in Lagouche may not apply. See notes 42 to 43 and accompanying text post. Examples of such countervailing values may include, depending on the circumstances, preserving the right of the accused to fundamental fairness in the jury selection process. In this case, the District Court erred in several respects. First, it failed to give proper weight to the presumption of the access that attaches to documents filed in the connection with the summary judgment motions. The District Court reasoned that the summary judgment materials were, in brackets, entitled to lesser presumption of access because, in brackets, summary judgment was denied by the court, brackets. In assigning a lesser presumption to such materials, the District Court relied on a single sentence of dictation from our decision in United States versus Amodio. We have since clarified, however, that this sentence was based on a quotation from a partial concurrence and partial dissent in the DC Circuit, and is thus not a considered decision of either this court or the DC Circuit. In fact, we have expressively rejected the proposition that different types of documents might receive different weights of presumption based on the extent to which were relied upon in resolving the motion for summary judgment. And I'm going to read the footnotes here. Our discussion there focuses specifically on the District Court's denial of Harold's motion to unseal the entire record. So it's the Miami Herald that wants it all unsealed. Rightly so. I mean, what I feel is that Trump was in power when Epstein went to prison, and he was found unalive the next day, in jail before his trial, and it is suspect. It does raise questions, and I think people presumed this and knew this but couldn't say nothing. And that might be part of why the Liberals didn't say anything, sort of like a gag order. Our discussion, and that's what it sounds like to me, our discussion, wait there, what was that on the Herald? Because this decision grants relief to all appellants, we need not discuss any separate additional error in the District Court's denial of earlier motions to unseal. See, that's the thing, isn't it? If it's untrue and then it comes out and gets thrown out, then why should the Herald know that? That I get that. It's not a reason for that. I know what that means. In the District of Columbia Circuit has pointed out, for example, that where a district court denied the summary judgment in motion, essentially postponing a final determination of substantive legal rights. A public interest in access is not as pressing. Internal quotation marks omitted emphasise in original discussion, when you've talked about it, that's all. Weight of assumption based on the extent to which they relied upon in resolving a motion for summary judgments. Second, in district court failed to review the documents individually and produce specific on-the-record findings that sealing is necessary to preserve higher values. Instead, the district court made generalised statements about the record as a whole. This too was a legal error. Finally, upon reviewing the summary judgments materials in the connection with this appeal, we find that there is no countervailing privacy interest sufficient to justify their continued sealing. Remand with respect to these documents is thus unnecessary. Accordingly, and to avoid any further delay, we order that the summary judgment documents, with minimal redactions, be unsealed upon issuance of our mandate. To talk about before, footnote 20, example Giuffre summarily concluded that all summary judgment judicial documents openly refer to and discuss these allegations of assault and trafficking in comprehensive detail, and that those allegations establish a strong privacy interest here. Ordering that the mandate shall issue forthwith to expedite the unsealing process. I mean, what if President Trump was getting blackmailed or extorted because of the things he knew? They knew, and it's like you could have such a hold on a person by something this sick, you could. Upon assurance of our mandate, the minimally redacted version and the summary judgment record will be made accessible on the Court of Appeals docket. And we have implemented minimal redaction to protect the personally identified information such as personal phone numbers, contact list, birth dates, and social remaining sealed materials. Now, what we got to realise, right, is we got to pick through the nuts here and see which one we can have. Like sometimes a birth date might come up or a specific date that specifically we've got to keep certain people in mind. Yeah. So if you can give me any dates, birth dates relating to the dates on there, anything like that of people, please put them on the comment list, please, because I'd like that. Yeah. Remaining sealed materials. The law governing the disclosure of the remaining sealed material in this case is only slightly more complex. Breaking now. Slightly, you're telling me it's like 3,000 pages. This. The Supreme Court has recognised and qualified net right, in brackets, to expect and copy judicial records and documents. In defining the judicial records and documents, we have emphasised that the mere filings of the paper or documents with the court is sufficient to render the paper a judicial document subject to the right of public access. 24. Instead of the item filed must be relevant to the performance of the judicial function and useful to the judicial process in order for it to be designated into a judicial document. What I realised watching the Diddy trial as well, like the verdict is on beyond a reasonable doubt, and this is what it was with Epstein too, and most trafficking cases. As our precedent makes clear, a court performance, the judicial function, not only when it rules on motions currently before, but also when properly exercising its inherent supervisory powers. Security numbers. We have also redacted the names of alleged minors victims of abuse from the deposition testimony and police reports, as well as deposition response concerning intimate matters where the questions were likely only permitted and the response only compelled. Because of the strong expectation of the continued confidentiality, while we appreciate the views expressed in the judge pooler's separate opinion, the panel majority believes that the efforts invested by the three former district judges in reviewing these materials adequately address those concerns. Explaining that, in consideration whether the report of a monitor charged with accessing compliance with a deferred prosecution agreement is a judicial documents is thus relevant to the performance of the judicial function. If it would reasonably have the tendency to influence a district court's ruling on a motion or in the exercise of its supervisory powers, without regard to which way the court ultimately rules, whether the document ultimately, in fact, influences the court's decision. That's right. Accordingly, if, in applying these standards, the court determines that the documents filed by the party are not relevant to the performance of the judicial system, no presumption of public access attaches. Convenience. That's worth screenshotting. So, no presumption of public access attaches. So, there you go, people. We don't matter. Once an item is deemed relevant to exercise of judicial power, the weight to be given the presumption of access must be governed by the role of the material at issue in the exercise of Article 3 judicial power and the resultant value of such information to those. Let's get past that. To those monitoring the federal courts. Thus, while the evidence introduced at the trial or in connection with the summary judgment enjoys a strong presumption of the public access documents that play only a negligible role in the performance of Article 3 duties, are or accorded only to a low presumption that amounts to little more than a prediction of public access, absent a countervailing reason. Documents that are never filed with the court but simply passed between parties in discovery lie entirely beyond the presumption of reach. I'll go back to these footnotes here and read those for us. Okay, because it makes a lot of sense, these things, you know. The district court's conception of its supervisory powers in this context were correct. The monitor's report would quite obviously be relevant to the performance of the judicial function and useful for judicial process. Internal quotation marks omitted. Whether a specific judicial decision constitutes as a performance of the judicial function is a question of law, according to we review such a determination. Concluding that the documents were relevant to the performance of the judicial function because they would have informed the district court's decision whether to discharge or refrain a receiver. Retain a receiver. Cited Federal Rule of Evidence 401's having any tendency definition of relevance in determining whether documents were judicial documents. As we explain below, there are several often preferable tools beyond sealing that district courts can use to protect their dockets from becoming a vehicle for irrelevant and potentially defamatory accusations. It's not defamatory if it's true, though. The remaining sealed materials at issue here include filings related to inter alia motions to comply testimony to quash trial subpoena and exclude certain deposition testimony. All such motions, at least on their face, call upon the court to exercise its Article 3 powers. Moreover, erroneous judicial decision-making with respect to such evidentiary and discovery matters can cause substantial harm. Such materials are therefore of value to those monitoring the federal courts. Thus, all the documents submitted in connection with and relevant to such decision making are subject to at least some presumption of public access. Note 33, this footnote says, in previous decisions, we have identified an important exception to this rule. The presumption of public access does not apply to material that is submitted to the court solely so that the court may decide whether that they're saying, we'll have to wait for a minute. Although the court's authority to oversee discovery and control the evidence introduced at trial surely constitutes an exercise of judicial power. We note that these authority is ancillary to the court's core role in adjudicating case. Accordingly, the presumption of public access in filings submitted in connection with discovery disputes or motions in LMA is generally somewhat lower than the presumption applied to material introduced at trial or in connection with dispositive motions, such as motions for dismissal or summary judgment. Thus, while the court must still articulate specific and substantial reasons for sealing such materials, the reasons usually need not be compelling, as those required to see summary judgment filings. It is compelling, it's needed. Here, the precise basis for the district court's decision to deny the motion to unseal these remaining materials is unclear. In the 3 paragraphs devoted to the issue, the district court emphasised the potential for embarrassment. Person's face going red isn't the reason you should not unseal them. Given the highly sensitive nature of the underlying allegations, and concluded that the documents sealed in the course of discovery were neither relied upon by the district court in rendering of an adjudication nor necessary to or helpful in the resolving motion. It is therefore unlikely whether the district court held that these materials were not judicial documents, and thus are documents materials must be disclosed in discovery process or shielded by a protective order. Often not subject to the presumption of public access, or found that privacy interest outweighs a limited right of public access. On either interpretation, however, the district court's holding was error. Insofar, the district court held that these materials are not judicial documents because it did not rely on them in adjudicating a motion. This was legal error. As explained above, the proper inquiry is whether the documents are relevant to the performance of the judicial function, not whether they were relied upon. Indeed, decision makers often find that the great deal of relevant material does not ultimately sway their decision, and so far as the district court held that privacy interests outweigh the presumption of public access in each of the thousands of pages at issue. That decision, which appears to have been made without particularized review, amounts to an abuse of discretion. In light of the district court's failure to conduct an individualized review of the sealed materials, it is necessary to do so now. We believe the district court is best situated to conduct this review. The district court can... I'm recording here. District court is best situated to conduct this review. The district court can directly communicate with the parties and can therefore more swiftly and thoroughly consider particularly objections to unseal specific materials. Relatedly to the district court can obtain the parties' assistance in effecting any necessary redactions and in notifying any outside parties whose privacy interests might be implicated by the unsealing. And to carry on, explaining that the abuse of discretion is a non-pejorative legal term of art. Yeah, it is. It's making choices, isn't it? It's sort of made the choice to keep them sealed from the public and not do an inquiry. You know, I mean, at least do an inquiry. That way you can say this. Let's address it. It doesn't seem like it's happened in this case yet. You know, so maybe it will have to go back to like that. You know, if the files are available. But I don't feel that Donald Trump is the only one who's had access to those files. So, you know what I mean? But then again, he was president twice. So, I don't know. I don't know what's going to happen there, because the things I've been finding on Donald Trump, allegations on that shit sticks, doesn't it? You know? I'm not sure I believe them. I'm not sure. I can't read them type of things. I did one the other day on my file, and it was a complaint, and I couldn't even listen to it the second time I had to edit it. So I just left it and put it up because I just didn't want to hear it again. And this man is a monster, you know. It's not. You see, with these people, with Diddy, I'm not sure, you know, but with Epstein, he used these girls. He just put his hands on these girls out the blue. Terrified, 15, this creepy old guy, you know. All these scientists as well freaks me out a bit. The fact that, like, he wanted to make a human farm, you know, weird. Good job he didn't have any children, you know. I just don't know. I think he would be a very disturbing individual around somebody very young. People say, oh, not one of them have made accusation of more aggressive acts, but he has been accusations of aggressive acts, and I believe the girl. So, that was the one what we put up the other day. I say we, it's our channel. So to me, it's our channel. All 255 of you are here and understand how important this is to people, and I know how important this is to people, you know, because this isn't just in America, this is in the UK too. You know, I don't want to speak much because we get a lot arrested for all kinds of garbage in this country, you know. So if anything happens to me, no, it's nothing to do with me losing my mind, okay? It's to do with this. Because this is like, I didn't even want to post this on Twitter. I didn't want to, didn't want to, but at the end of the day, now the word's out the bag, I can do that, but I don't think anyone would have believed me at the time when I found it. Do you know what I mean? So, but I don't know. I thought a lot more people knew. So I asked Rock, as you do, you know, is it true that he was, an agent and all that? And I come back now. So, like, you know, AI tells me no. Other people tell me no. I don't feel it's that straightforward, and I feel that's the problem. There's so much impatience in the world, and everyone wants the right answer, but the right answer takes time. The goal of, like, getting this result will be long after I'm gone. You know, this is bigger than the tax thing with whatever Nixon. You know, it's huge. You know. I know that, like, there's something going. I've read reports on the royal family. You know, Prince Charles, his uncle Lord Batten, he used to have boys come around to his place. There's this vicar who has always been involved with Charles all his life. Had accusations made in him, and the person committed to, and I look at that and I feel so sad for these people, these boys and girls, and what I hate more is, like, now we hear about crimes against boys, but we've always heard about it for more since the 90s, because it does happen, and I just wish people would have more respect about that. Really, you know, people don't lie about stuff like that. Not really, you know, there's some kind of untruth to a lot of things that others have said, and then there's a lot of truth, You just got to find it. You just got to be able to point that out as well. Tell someone says something sometimes, isn't it? And that's what the beauty of your testimony is and your depositions are, because it gives credence to the evidence and to the alibis and the people involved. I don't think Epstein was the only one involved. I've never thought that he was the only one. And Glenn, when her father mysteriously fell off the boat, I've heard that like someone left her a letter on the boat, and straight away she went to visit Epstein. It was to do with Epstein that she left, because she needed looking after. Basically, she needs to be useful. You know what I mean? She was in charge of something that her father was in charge of, and I suppose she probably didn't know what to make of it at first. I'm not sure if he was an agent himself, but something to do with Mossad. I don't know, you know what I mean? And again, I don't know much about Mossad as well. But this is it with Epstein. Is that what happened? I mean, is there presidents from? I've heard there's presidents from Israel. I've heard there's presidents probably from prime ministers. So that means UK, doesn't it? Hi, baby. Cat's meowing. Prime Minister is the UK governor, yeah, the main president. Yeah, if you don't know, if you're from America. So it's one of our prime ministers, maybe in the 80s or in the 90s, but I'm trying to think who it could be, But we've had scandal like that, and then people have ended up passing away. And it makes sense, because the moment someone speaks out about these things, it does sort of mysteriously ruin their lives, or they ended up having no life, I'm a bit scared. I know that it's important, it's important because I don't want girls being taken advantage of, or boys, or future children.